This is legal dictation. Ready, start. Labor Law Industrial Disputes Act 1947, Section 17B, Proviso workman concerned if gainfully employed elsewhere after dismissal determination of material to be considered. In present case, appellant employer placed before High Court copies of vouchers showing payment of salary by transport companies to respondent, where respondent had worked after dismissal from appellant with supporting affidavit held. High Court failed to take into consideration material relevant for deciding controversy before it. Hence, matter remanded for fresh adjudication in accordance with law. Leave granted. Challenge in this appeal by the management is to an order dated 2/8/2007 passed by an appellate bench of the High Court of Judicature of Rajasthan, Jaipur bench in CSAW number 339 of 2005, whereby the order passed by the learned single judge directing the management to comply with the provisions of Section 17B of the Industrial Disputes Act 1947. For short, the Act has been affirmed. Since the issue involved in the appeal is sought with the consent of learned counsel for the parties, we proceed to dispose of the matter at this stage itself. Mr. Dhruv Mehta, learned counsel appearing for the appellant bank, submits that in the first instance, the learned single judge, while allowing the application preferred by the workman under Section 17B of the Act, has proceeded on the premise that the management had failed to controvert the specific plea of the workman that he was not gainfully employed, whereas in para 4 of the reply filed by on behalf of the appellant to the said application, their specific case was that after his dismissal the workman had worked in two transport companies for different periods. Copies of the vouchers showing payment of salary by the transport companies were placed on record with the supporting affidavit. It is asserted that the workman did not rebut the said material. The learned counsel thus contends that the learned single judge as well as the appellate bench, having ignored the said evidence, the impugned direction deserves to be set aside. Learned counsel for the workman, on the other hand, has supported the impugned orders. Having heard the learned counsel for the parties and perused the material on record, in particular the reply filed by the management refuting the claim of the workman that he was not gainfully employed with supporting evidence, we are of the view that the High Court has failed to take into consideration the material which was relevant for deciding the controversy before it. It is clear from the order of the learned single judge that he had proceeded on the basis that the statement of the workman that he is not gainfully employed has not been controverted by the management, which fact, as noted earlier, is not correct. In view of the factual scenario as emerging from the record, the impugned orders cannot be sustained. Accordingly, the appeal is allowed. The orders passed by the appellate bench as well as the learned single judge are set aside and the matter is remanded back to the learned single judge for fresh adjudication in accordance with law. No costs.